Good. Yeah, I think so.
That's me. Yeah, so like Peter said, yeah, I do estate planning, state administration on the flip side of that, after someone is deceased, trust administration as well, and then some litigation. And then most of the business work I do would be closely held business work. So we're talking family companies with 20 shareholders or less. And that's succession planning, organizational, and some buy-sell stuff as well. But today we're going to be talking about estate planning. The agenda is we're going to learn what it is, why it's important, clear up some uncertainty. I know there's a lot of uncertainty around the area of estate planning, and then answer some of your questions. So here's the outline for today. Talk about why you need to do it. Then we're going to dive into the documents themselves, spend most of the time there, filling your roles with people, the fiduciary appointments, and some keys to success. And then we'll talk about taxes and some other considerations. Death and taxes, right? Failing to plan is planning to fail, insert all these other corny phrases. But I mean, the truth is, an American dies accidentally every 3 minutes. You are rarely planning for your own death or have time to do that. So that's where someone like I come in and assist you with that. Some reasons why people delay their estate plans. This is according to caring.com, 40% just say I haven't gotten around to it. Like I just said, you won't get around to it. You just have to do it. 33% said they don't have the assets. They don't have enough assets to leave anyone. And that's probably the most common answer I hear is from people sort of on the fence is, oh, I don't think I have enough that it's worth it, the time and expense. It's not so much the amount of assets you have, but really the form they take. How many of you have actually gone through probate for someone you love and the executor or beneficiary? Yeah, it's long, it's arduous. And even if it's, a car, it still takes time and money to do that. It's too expensive to set up. It's far more expensive for your heirs to go through probate than it is to set up an estate plan. And then I don't know how to put it together. Well, after today, you will. So let's dive into the documents themselves. Some of the things the documents cover, things you'll be thinking about during an estate plan while you're making considerations for the next generation. Obviously, your children. Do you have minor or disabled children? This documents will take care of those. Who do you want to directly help financially or indirectly help? What's more important, being fair to your beneficiaries or giving them what they actually need? That's a big one that comes up a lot. Specific financial preferences. Education is a big one for a lot of people. Provide for education, but they don't want to have their, give their grandchildren or children access to large amounts of sums, because I know if I was young, it wouldn't be here anymore. Charitable goals, business succession planning. That's another big one. Making sure that if you are part of a business, most businesses in America are small family-owned businesses. And so making sure that they have proper cash flow, liability insurance, and all that stuff set up properly so that the next generation isn't surprised by any debts or anything like that. Debts, and then end-of-life care for yourself. That's another big one. So this is a big point, and this is often where a big source of confusion is in estate planning. There's really two sides to estate planning. There's after you pass, what happens to your stuff, and then there's what happens while you're living and becoming incapacitated and can't make decisions for yourself. And no one ever thinks about that first one when they're thinking estate planning. They're thinking wills. When I talk about estate planning, people think I got to make a will. I got to make a will. I got to make a will. Well, that's only half of it. The pre-death aspect of estate planning is just as important, sometimes more important than the post-death planning. So for the pre-death planning, you've got really 3 documents and planning tools that you use. You have a financial power of attorney, a healthcare power of attorney, and a living will. And we're going to talk about those first. So your power of attorney for your finances, what this does is it designates an agent who's a fiduciary, meaning they have to put your interest above theirs and act on your best interest. It allows them to essentially make any decision you could make financially. So they can sell assets, they can pay bills, they can make gifts according to your previous patterns of giving. Now, the Ohio bar and the legislature has put together what they like in a form that says, here's all the things you can do just by signing at the bottom of it. We like to add additional things that the state of Ohio says, these are such a big deal, you need to actually expressly designate in the document. Things like changing beneficiary designations. So the way we advise clients for financial powers of attorney are, we're going to start and just give them every power you could possibly imagine. Do anything you could do financially, and then we'll start peeling it back from there. So for second marriages, we might say, you can't change beneficiary designations because I want my kids getting stuff after you pass, things like that. So that's the financial power of attorney. The healthcare power of attorney is similar to the financial power of attorney, except it just applies to healthcare. It allows your agent to give and receive healthcare information, as well as make healthcare decisions on your behalf if you can't. Unlike the financial power of attorney, though, the healthcare power of attorney only goes into effect usually when you become incapacitated. The financial power of attorney goes into effect usually immediately, so you don't have issues with institutions when you need to get funds. A key point for the healthcare power of attorney is, and the financial power of attorney, when you're making these documents and you're setting up your estate plan, a lot of people think, I'm going to set my estate plan up and I'm going to have the documents, put it in a binder, it's going to sit on my shelf, and when I die, people are going to get it out and read it, and here's what they'll do. That's not the way to do it. What you should do is you should discuss with your fiduciaries and your beneficiaries what your plan is, so that no one's surprised. Most litigation, fiduciary litigation, happens when someone's blindsided, right? They're expecting a big windfall of cash and they didn't get it, or they're expecting to be the healthcare power of attorney and they're not, and they think mom should go to this care facility rather than that care facility, so they fight about it. So keeping your agents informed about your wishes will avoid those contentious relationships. The last while you're living document is the advanced directive or living will, and this is the pull the plug document, for lack of a better term. What this does is it outlines your wishes if you have a terminal illness. And there's a lot of uncertainty surrounding this document. I spent a lot of time in meetings talking about this document because it's a big deal. It's what the document essentially says is it's your intent that if two doctors agree that it's virtually certain you are unable to improve from a vegetative state, you're telling the world by signing this that it's your intent to not be kept alive on life-sustaining treatment. And again, it's two doctors. It's usually the doctor who's your primary care physician, if you have one, and then the doctor who's treating in the area you're struggling with, excuse me. Now, these documents won't remove end-of-life comfort care. It's just life-sustaining treatment, if that makes sense. Was anybody around or remember the Terry Schiavo case back in the 90s? So for those who don't remember it, she was like 27 or so in 1990. She went into cardiac arrest and because of that had lack of oxygen to her brain and became in a vegetative state from 1990. It wasn't until she didn't have a living will, and this is the most famous case for someone not having a living will and why they're so prevalent now. She was married. Her husband in 1998 started proceedings to become guardian to have her life-sustaining treatment removed, a feeding tube. She had a feeding tube. So that's 8 years that she'd been in a vegetative state. The litigation, so her parents were on the opposite side, and they said, we don't think that she would have wanted to be, her life-sustaining treatment to be removed. We think she would have wanted to be kept alive. So her parents argued that. It was litigated for 8 more years. It didn't get settled till 7 more years, 2005. So she was kept alive for 15 years. Whether against her will or not, we don't know because she didn't sign a living will. But these are the kind of scenarios you get into litigation if you don't have a living will. It's people fighting. So those are the documents themselves. Another big key that these things help with is that they avoid another negative, and that's the need for guardianship. So practically speaking, what happens when someone becomes disabled, let's say a husband becomes disabled and his name is on the investment account. The wife needs to liquidate some funds to pay bills. Well, she goes to the broker, and the broker's going to say, that's fine, we can liquidate some stuff, just have your husband come in. She's going to say he can't, he's incapacitated right now. The broker's going to say, fine, show me your financial power of attorney saying you could liquidate. She's going to say, I don't have one. And he's going to say, fine, give me a letter signed by a judge that says you can liquidate funds. So without a financial power of attorney or a healthcare power of attorney, the only way you can act on behalf of your loved one is to become their legal guardian. And to do that is a long, expensive process. It takes months to do. It's intrusive. It can be embarrassing for the incapacitated person. If you're determining competency, you have to have doctors determine that they're incompetent. That's not a fun process for people to go through. Even if they are incompetent, you don't want people telling them they are. And then once a guardian's set up, it's expensive to do, and it's public. The guardianship is run through the probate court in the county in which the disabled or incapacitated person is. So anytime the guardian wants to do anything for the ward, is what they would call the incapacitated person, they need court authority. So you want to buy them a stick of gum, you need a judge to sign something that says you can do that. You need to do annual accountings. So that these powers not only just ease the process for your loved ones in your care, but they also avoid the public embarrassment, for lack of a better term, and the process of a guardianship. So that's the pre-death planning. And like I said, that's just as important as the post-death planning, because everyone's going to become incapacitated, whether it's for a split second before you die, or whether it's for more likely 10 minutes, an hour, a day, a week, 6 months. You will become most likely incapacitated, and you need to have those documents in place. So post-death, excuse me, I'm going to get a drink. So how many people in here have been an executor of a will? So a few. How many have been involved in a state where there was no executor? Anybody? No? There we go. Okay. So do people generally have an idea what probate is? Probate is the statutory appointment through which a court decides how assets are distributed via a will. So probate is public. It costs a lot of money. It's time consuming. It may not align with your wishes, and it has a lot of family drama involved often. So again, it's a judicial process for settling an estate. Without a will, it's very complicated. The Ohio Revised Code is going to say where your stuff goes. They decide who gets what based on your heirs at law. If you have a will, it's going to be simplified. If it can also be avoided, though, if you have trust and proper beneficiary designations. Just some interesting statistics from the Gallup poll of people who don't have a will. I think the most surprising is from 50 to 64, 53% of people don't have a will. That's kind of scary. So what is a will? A will defines the distribution of your assets. It appoints an executor to carry out the provisions of it. And then in that will, it's going to give the executor powers to administer your estate. It only takes effect after your death. Now, even though a will appoints an executor and gives executor powers and directs your assets, it still has to go through probate. A lot of people, there's confusion with this. A lot of people think, I have a will, I don't have to go through probate. That's not the case. A will has to be probated. If you take a will to a bank, say, look, I'm the executor, they're going to say, I don't care. We need to see a letter of authority from a judge saying you are appointed executor. You just nominate your executor in your will. The judge appoints them, and then the judge, and with the assistance of a lawyer, the executor carries out the wishes of the will in the probate court, where they file an inventory, and then they file distributions. The whole thing's public and overseen by the court. The other thing a will does is it nominates a guardian for minor or disabled children. But if you have disabled or special needs kids, a will probably won't be sufficient, because most state, and if they receive benefits, you can't really devise assets to a child with special needs, because that might disqualify for them for benefits. So usually trust is necessary for that. So let's talk about a revocable living trust. This is really the meat and potatoes of an estate plan. Like I said, a will is what people think about, but what we really like to use a will for is sort of a safety net. We want to make sure everything gets into a trust. Most scenarios, we want to make sure everything gets into a trust via beneficiary designation or directly to the beneficiaries via beneficiary designation. And by beneficiary designation, I'm talking about you go to your bank and you say, I want this checking account payable on death to my son, payable on death equally to my children or my spouse. That's what a designation is. A revocable living trust is set up while you're living. That's why it's called a living trust. It's revocable, meaning you can amend it, alter it, change it as long as you want until you pass. You serve as your own trustee. Trustee is the person in charge of running the trust according to its terms. And usually while you're living, you're the trust beneficiary as well. Really, the trust is just there to catch things when you pass and administer them after you pass. There are a lot of scenarios, we won't get into most of them, where you could have a trust for advanced planning, where you might need to be the beneficiary of your own trust and have someone else's trustee. So again, the revocable living trust kicks in after your death, becomes irrevocable at death, meaning the terms can't be changed. It's locked in and the trustee is charged with running it according to its terms. Your successor trustee is designated in the document, meaning you pick, and usually there's a line of people who you might pick. So, for instance, I have my father-in-law, then my brother, then my wife's brother, and so on and so forth. Assets in the trust, and this is the big key here, are not subject to probate, meaning nothing will ever be public in the trust. So, some other advantages, like I discussed, it's faster distributions, it's private, it can also delay distributions. You can plan around young, minor, or adult children with disabilities, flexible during your lifetime. The successor trustee can make decisions when you're incapacitated. And because it's a self-settled contract, is what a trust is, it can basically say, whatever you want it to say. You can get really creative with how these things work. Filling your roles. So these are the people you're going to put in charge of your estate plan. For your will, it's called the executor. And then again, the guardian of your minor children. For your power of attorney and healthcare power of attorney, they're called your agent. Revocable living trust is your successor trustee. You'd be your own trustee. And then for your living will, you don't have one. That's just your proclamation of your wishes for end of life. So you should probably try to think about the roles individually rather than just, which kid do I like the most? If you have a daughter who's a financial advisor, maybe she should be the financial power of attorney. If you have a son who's a nurse, maybe he should be the healthcare power of attorney. So everything should be thought of individually rather than, John's the oldest, he's going to be the primary fiduciary on all the documents. Keys to successful planning. Create an inventory of your assets. You own more than you think. A lot of people think, oh, I don't own that much. You do. And if you went through and listed everything you'd own, you'd realize this is going to be a nightmare when I pass and if it has to go through probate. Everything's going to be public and your heirs are going to have to deal with gathering all that up and getting those to the right people. Communicate, in fact, overshare with your family. Like I said earlier, you don't want people to be blindsided. You want them to, if someone's going to contest something, it's because they were blindsided. If they know going into your estate plan that dad said he's going to give my brother more than me because X, Y, Z, they're less likely to contest your estate plan and litigate, which is going to cost your estate money if they know that up front, compared to whether they're surprised. And then review and update as life goes on. We recommend, every year, maybe not updating, but thinking about your stuff. And then real quick, this is the last point. A lot of people always ask about taxes. Am I going to know estate taxes? The quick answer is most likely not. The legislation has stated that everyone has a combined exemption amount, meaning you don't have to pay estate taxes until you reach a certain ceiling of assets. And that ceiling for individuals right now is just about $13 million per person. So anything over $13 million that you die with is subject to estate taxes. But there is a side note for that's combined with your gifting amount. So they say the amount you can give away during your life is the same amount as the estate tax. So you probably won't fall into those unless you're in the lucky 1%, but you might have to file tax returns if you gift more than $17,000 per year. If you do, you can, for a daughter's wedding, if you pay for a wedding for $25,000 or something like that, which is the next slide. If you're an individual, you'd have to file a tax return for the surplus over $17,000 per year, which is what you're allowed to gift. Anything over that, you file the gift tax return for. You probably won't owe the tax, but again, the IRS just wants to keep track of your lifetime exemption amount. So you file a return, no tax will be owed. When you die, they'll be, they'll add up all the exemption you used. If it was more than 12 million or 13, you'll owe tax. Again, that probably won't happen to most people. If you have that issue in this room, very good for you. We should talk after. I think am I good?
Yeah, how about we start taking questions?
Questions? I flew through a lot of stuff there, so sorry to go ahead.
I have a question. So in a hospital and CCU or ICU, person has a living will, they have they have all the documents. The hospital will still honor whatever the family says over the patient.
Yeah.
What the heck do you do about that?
Yeah, that is usually the hospital. Hospital never wants to be a party to a complaint in litigation. So what you really need to do is talk to the doctors in that scenario, because it depends on who the doctors work for. If the doctors work for the hospital, then you're sort of stuck. If the doctors are contracted, then you need to convince the doctors of the living will. Again, the living will supersedes a healthcare power of attorney. But often, like you just pointed out, doctors and hospitals are not quick to pull the plug because they don't want to get sued. So you really need to push, even with a living will, you really need to push. I mean, this is a sad set of facts, but you really need to push to pull the plug.
Josh, I'll have the final question. At a Rotary meeting, one of our district guys said what he did is he wanted to do a bequest for Rotary, which is one of our ways of giving. But wait, he set it up so that after he and his wife pass, then Rotary gets the 8 or 10,000 or whatever it was. Is that done frequently? Do people often say, well, as soon as both of us are gone?
Yes, and especially if you're a married couple with a joint plan, you often have specific requests kick in only when the second spouse dies, and that's actually more common than not, is having that.
Okay.
Actually, I'm going to jump in. I want to ask one last question. So, Josh, if you die without a will under Ohio's rules of intestate succession, I believe that usually the order is it goes to your spouse and then to your kids.
Yeah.
So let's say your husband and wife, and you've got 2 kids, and they're adults, so you don't have to worry about guardians and stuff. Most people, that's how they want their estate to go. Is to go to my spouse, and then if my spouse doesn't survive me, then to my kids.
Yes.
Why would a will be an improvement over that scenario?
What you're protecting against is not just trying to avoid probate by doing a trust, but if you're just doing a will, you don't know what your spouse will do with that money. If you die with children, and the children are it's not a blended family, it's all going to your spouse, none to your kids. So it all goes to your spouse. If your spouse gets remarried after you pass, she would have all your money, and she could potentially cut your kids out. So that's one thing to do. If you want to ensure your kids get funds, again, this is an unlikely scenario that would happen, of course. But
no, I don't trust my.
But to ensure, the only way to ensure the people you want get the only way to ensure the people you want get what you want them to get is to write it down. We have all the time people saying, well, Dad told me he wanted this. Dad told me he wanted that. Mom said she would have wanted this. Oh, this is what they would have wanted. It's like, that might be what you think they would have wanted, but they had a chance to write it down. They didn't. So the state's going to say what they wanted. So that's why.
Josh, do you have a minute to stay afterwards?
Yeah, of course.
Josh, thank you very much.
Yeah.
Josh, thanks for coming and thanks for staying a little bit, just a few minutes here. Next week's program is going to be all about the OSU's 60+ program. So come and bring some guests that you think would be able to take advantage of some of those programs. And our closing quote today is always plan ahead. It was not raining when Noah built the ark. Richard Cushing. Thank you all. Have a great week.
Yeah.